serial number 962 of 2025. It was lastly listed on 9/10/25. Arguments were concluded, and on the date of 13/10/2025, some of the exhibits have not been forwarded from the lower court. So the honorable asked for the lower court records. It came, but after that it never came into.
Those documents have already been exhibited. So there is no question of any additional evidence.
I only pray maybe the
Just
date
here.
may be fixed.
Why? Today is
So
the
it's
date
coming
fixed.
for the past 3 months. It's coming into the.
Today is the date fixed. Today is the date fixed. You just wait for some time. You just see.
It's hard. It's unlikely that it will be. It's serial number 9. Patent disclosure. Any date may be at some.
You
fixed
just
time.
wait for some time.
From the daily list at 2:50.
If it is not taken up before rising, we'll fix the date. Right?
Under heading for orders targeted case item 1, second appeal 556 of 2004 assigned.
So in the last week, file notice and Nama of appeal, even I have appealed. We have filed the Nama and notice and also.
Yes.
कोई सर्च हमको नहीं है, आपको जो करना है कई बार खबर भिजवाए क्या
इन्होंने जो आईए फाइल किया है उसका जवाब दाखिल किया आपने?
जी वो मेरे हस्बैंड का लड़के से मेरे हस्बैंड हाँ वही किए हुए
हाँ तो इसके बारे में कुछ बोलना है आपको?
जी
आपको कुछ बोलना है?
हमसे बातचीत कुछ करता नहीं है, कब कई बार खबर क्या करें?
आपके हस्बैंड आप कहाँ हैं? He has expired. Very unfortunate. Is he the only counsel on record? Is he the only counsel on record? Respondent की तरफ से?
Yes,
आपका वकालतनामा नाम नहीं है?
इनका नाम छप रहा है।
नाम छप रहा है?
एमएस मिजुना ठाकुर।
She is also there.
yes.
She is also holding वकालतनामा. सारे प्रपोज लीगल ईयर्स की तरफ से फाइल कर दी.
Yes.
अपील नंबर 1.
Yes.
Where is the substitution petition of appellant number 1?
IA number 2960 to
2960. Just a minute. Appellant number 1 expired on 13/11/2010, right? And his IA application is IA number
2960.
नहीं 2960 उनका IA नहीं है.
Substitution of the name of the applicant number.
2960.
तीनों का एक ही है।
तीनों पे एक ही आई है
Applicant number
2960.
1, respondent number 4 and respondent number 5. तीनों का एक ही है।
And there are two other IA.
One is for limitation and other is for setting aside development.
Limitation concern. IA number
2961. I know 2961.
The Learned Council for the Appellant has submitted that IA number 2960/2013 has been filed for substitution of Appellant number 1 and Respondent number 4 and 5. Appellant number 1 has expired on 13/10/2010. Respondent number 4 on 18/3/2008 and Respondent number 5 on 14/11/2010. Correct?
Appellant number 1 has expired on 13/11/10.
हाँ यही लिखा है ना, ये ऑर्डर में भी है, ये 5/1/26 के ऑर्डर में इट इज रिकॉर्डेड. Appellant number 1 on 13/11/2010, Respondent number 4 on 18/3/2008 and Respondent number 5 on 14/11/2010. He has submitted that a petition for setting aside abatement and for condonation of delay has been filed through IA number 3921 of 2025 and IA number 2961 of 2013 respectively. He has further submitted that there is delay of substitution with respect to Appellant number 1, which is 625 days, with respect to Respondent number 4, it is 1651 days, and with respect to Respondent number 5, it is 624 days. He has further submitted that so far as the legal years and successors of Appellant number 1 is concerned, he has already filed wakalatnama on their behalf. Notices were issued upon Respondent number, the proposed legal years and successors of Respondent number 5. He submits that considering the office note, the notice be accepted as validly served, inasmuch as the Respondent number 4A, 4B, 4C, 4D, 5, 5A, 5B, 5D and 5E has been received by themselves, and so far as Respondent number 5C is concerned, it has been received by the Respondent number 5 within bracket 3, who is admittedly his close relative. Counsel for the respondent has submitted that she has no instructions from the proposed legal years and successors of Respondent number 4 and Respondent number 5. Considering the office note, the notice upon Respondent number, proposed legal years and successors of Respondent number 4 and Respondent number 5 is accepted as validly served. So far as to this counsel for the petitioner, appellant has submitted that the matter has remained pending before this court since 2004, and in the meantime, the aforesaid, the appellant number 1 and Respondent number 4 and 5 have expired. Partition सूत्र क्या है?
Title should be.
Submits that the prayer for substitution be allowed after condoning the delay and setting aside abatement. Considering the fact that the appeal has remained pending before this court since 2004 and was admitted for final hearing by order dated 7/5/2009. And earlier petition seeking substitution of appeal number 1, 4 and 5 was filed through IA number 2248 of 2012. And one another IA 3258 of 2012 was also filed. However, those applications were permitted to be withdrawn with the permission to file fresh one by order dated 3/5/2013. And thereafter the present IA being IA number 2960 of 2013 has been filed, and then the IA number, the other two IA seeking combination of delay and setting aside abatement have also been filed. Being satisfied with the cause shown as mentioned in the interlocutory application, the prayer seeking combination of delay in filing the petition seeking substitution is allowed. The prayer for setting aside abatement is also allowed, and consequently the substitution of the prayer for substitution of appeal number 1 and respond number 4 and respond number 5 are also allowed. The learned counsel for the appellant is directed to delete the name of appeal number 1 from the cause title and appeal number 1, appeal number 4 and appeal number 5 from the cause title, and insert the name of their legal heirs and successors in writing. अब बताइए क्या करेंगे? हो गया आपका सब्स्टिट्यूशन का काम. अब आपके सीनियर कौन है? Within a period of 1 week from today. Holds the space for final disposal on next Wednesday. उस दिन टाइम मत मांगिएगा, 2004 का केस हम टाइम नहीं देंगे, ठीक है? आपका सारा डिले सब कंट्रोल कर दीजिए. आप भी तैयार होइए मैडम, वकालतनामा है आपका.
जी मेरा है.
हाँ तो आप नहीं बोल सकते हैं कि इंस्ट्रक्शन नहीं है, ये सब कहानी नहीं चलेगा ना. वकालतनामा दिए हैं तो आपको जस्टिफाई करना है.
इधर नहीं कोई टच कर रहा है.
कोई टच का कोई काम ही नहीं है. रिकॉर्ड है, रिकॉर्ड पढ़ना है, बहस करना है, फिर क्या?
रिकॉर्ड तो सब मेरे फेवर में.
तभी ना आप रेस्पोंडेंट हैं, आपके फेवर में. चलो आप तैयार हो जाइए मैडम.
अच्छा कहिएगा, खबर दिए, गुस्सा लगता है कि
नहीं, गुस्सा आने से नहीं होगा. वकालतनामा है आपका, रिस्पॉन्सिबिलिटी है आपकी.
ये फंसे हुए हैं हम.
रिकॉर्ड यहीं पे मिलेगा आपको, यहाँ से पढ़ सकते हैं. रिकॉर्ड है ना आपके पास? हाँ
Under heading for final disposal, item 2, WPL 4657 of 2005.
This because I have got no instructions from my
Counsel for the petitioner submits that he has no instructions and accordingly
It's a case of 2005 not.
and he does not want to press this application. Counsel for the respondent has no objection. Accordingly, this petition business has not pressed. Next.
Signed the Item 3, WPL 4810 of 2012.
कृपा गोराई जी को बुलाएंगे.
जी.
Yes, madam.
It's the order under challenge examination 9 page 59. Complaint filed by the petitioner under section 26 of the Bihar Shops and Establishment that has been rejected is that there is an alternative forum created under the Sales Promotion Employees Condition of Service Act 1970.
That is the ID
Yes.
under the ID Act.
Yes. So let's say there were two issues which were framed by the legislature. The issues framed was, and this was second round of litigation was before that second year before that was it was decided in favor of
ID Act. Sales promotion.
Yes, Sales Promotion Employees Condition of Service Act 1976 and Jharkhand Shops and Establishment Act. That is. So
You
we
are related to sales promotion,
Sales Promotion Employees Condition
employees
of Service Act.
condition of service act.
I have
You are not covered by this act.
Let's be say let's that section first was you also can have a look at section 26 of the Shops and Establishments Act.
I just want to know what is your point.
Yes, the order is viewed is seamless. Two issues were framed by the
I have read it.
Yes.
You just tell me what
The
is
first
it.
issue is it is said that the court says that I am in the definition of employer. So it is not maintained. So my first objection is that
Managerial post.
yes, I cannot be an employer as per the definition was in the Shops and Establishment Act. I cannot be termed as an employer, and the reason given by the Labour Court is very.
You see,
yes.
the first point is that as per your own case, you are one of the sales promotion employees. As per your own case. So if the court holds on merits that you are in the managerial post or whatever, and at the same time holds that the case itself was not maintainable under the Shops and Establishment Act, then under such circumstances we have to see as to whether you are covered under IT Act or you are covered under the Shops and Establishment. If you are in a managerial post, will you still be covered under the IT Act or Shops and Establishment Act?
I am not in the managerial post.
Okay. If you are not in the managerial post, then Shops and Establishment Act is applicable.
But sir, as per a judgment, yours is a judgment, and as per section 11A of the Sales Promotion Act.
Okay. 11A.
Yes. The Shops and Establishment Act is not ousted from the 11A. The provisions of this Act or any of rule made therein shall have effect notwithstanding anything inconsistent with therewith contained in any other law such and such, provided that where under any such law, award, agreement, in settlement or contract or service, a sales promotion employee is entitled to benefits in respect of any matter which are more favorable to him than those to which he will be entitled under this Act. The sales promotion employee shall continue to be entitled to be more favorably benefited in respect of that matter, notwithstanding that he is entitled to receive benefits in respect of other matters under this Act. So far as termination, compensation, natural justice, notice floods, Shops and Establishment Act Section 26 deals with that. So we are claiming
It's not
that.
that. You see, if the import of this particular proviso is that if there is any other award or contract or any, you see,
Any other
law, yes, any other law, award, agreement, basically shops and establishment, etc., are procedural law to give you benefit. Industrial disputes is also a procedural law to give you benefit. These employees are governed by the Industrial Disputes Act,
Yes.
and you can't say that you are governed by both the acts. Can you say that you have alternative remedy amongst both the acts?
I'm not saying that. This ouster of jurisdiction, that was.
If you are covered by Industrial Disputes Act, can you still be covered under the Act itself provides a specific remedy under the Industrial Disputes Act, which will cover your point for termination also. So basically, the court has held that you have a remedy not under the Shops and Establishment Act but under Industrial Disputes Act. We can just observe that any observations made therein on merits regarding your status will have no bearing.
Merits is not entered.
No, he has entered into the merit to the extent that you are in the managerial post. Even that may have some bearing.
Yes, it has a.
It has a bearing.
It has a-
Therefore, once the court holds that the case itself is not maintainable, then under such circumstances you will have a remedy before appropriate forum, and any observations will have no bearing in that proceeding.
That will.
Right?
Yes.
You have a remedy under the IT Act.
Yes.
You avail your remedy. That should be sufficient.
Yes.
The learned counsel is appearing on behalf of the parties. This petition has been filed challenging the order dated 26th of March 2012, passed in BS case number 3 of 2002, passed by the presiding officer, Labour Court branching, whereby he has dismissed the complaint filed by the petitioner under section 26 of the Bihar Shops and Establishment Act 1953, read with Rule 21 of Bihar Shops and Establishment Rules 1955, holding that the case itself was not maintainable under the provisions of Bihar Shops and Establishment Act. The learned counsel for the petitioner, while assailing the impugned order, has submitted that on the one hand the case has been held to be not maintainable, and on the other hand the court has also entered into the merit of the case to some extent by holding that the petitioner was holding a managerial post. She has submitted that as per the case of the petitioner, he was engaged, he was working as medical representative who are termed as sales promotion employees as per Sales Promotion Employees within bracket Conditions of Service Bracket Rules Act 1976. The learned counsel submits that as per the provision of the aforesaid Act of 1976, the appropriate remedy is under the Industrial Disputes Act. She submits that. It would be suffice to observe that if the petitioner moves avails the appropriate remedy through Industrial Disputes Act, the observations made in the impugned award touching upon the status of the petitioner may not prejudice the petitioner in any manner. इस पर तो आपको कोई objection नहीं है?
This observation is already here. If I were to have a look at page number 69.
69.
This is already.
The learned counsel for the respondent has submitted that once the case has been held to be not maintainable, it has already been mentioned in the impugned award itself that there is no necessity to go into the merits of the case. He submits that if any observation to the effect that any finding in the impugned order will not prejudice the petitioner in any manner is made by this court, he has no objection. After hearing the learned counsel for the parties and considering the limited argument advanced by the parties, this court is of the considered view that the learned court, after considering the materials on record, has held that the case under the Bihar Shops and Establishment Act was not maintainable. Such finding has neither been assayed during the course of hearing, nor such finding arrived at by the learned court suffers from any illegality or perversity. Therefore, this court is of the considered view that it is certainly open to the petitioner to avail the remedy as per law, and it is sufficient to observe that any observation made in the impugned order with regard to the status of the petitioner will have no bearing in the adjudication of the case of the petitioner on merits if raised before appropriate court.
The limitation of
It is at this stage it is important to observe that this case was filed before this court on 22/8/2012 and has remained pending before this court. This petition is accordingly disposed.
Item 4, FA1 of 2022.
May it please this honorable court. Your Ladyship, I hope I am audible.
Yes.
Your Ladyship, I am appearing for the appellant with the unsuccessful defendant in a partition suit. This appeal was heard by Your Ladyship and an order of limited remand was passed on 26th of March 2025,
That's right.
order number 22, by which, in short, Your Ladyship, I will place the whole order if I am
I've read
called
it.
upon.
I have read it. The report has already come.
Yes, Your Ladyship.
Yes.
This
So
order
you are-
was passed directing the learned trial court to give me an opportunity to oppose the application which was filed for additional evidence,
That's right.
and that was done. But I was not given an opportunity to adduce rebuttal evidence.
I
The
don't know, there is an order
fixed the
passed.
date of 27th of August.
Yes.
Unfortunately, the
I don't know,
court,
that order is not under challenge. I just can't do anything about it.
Your Ladyship, I am in appeal against the judgment which is I filed an IA.
Are you challenging this order?
IA number 14345.
Challenging the order.
Your Ladyship, in the IA I have yes.
Now, after this order, just a moment. After this order, which is dated 26/3/25,
Yes.
there is one order passed by the court.
Yes. That order I have enclosed in the IA. I have brought on record the fact that this opportunity of reading rebuttal evidence was not given to me.
That
And
this order is under
therefore,
challenge.
This order is all right, Your Ladyship. The court has said that their evidence will be accepted. That's all right. I must also be given an opportunity to adduce rebuttal evidence. Now, what happened is, earlier order which was set aside by Your Ladyship, in that order he had said that I will give you an opportunity of rebuttal.
Okay.
And now when this order has been passed, please take the IA which I have filed.
Are you there for the response?
Yes.
You want to respond to this? Ali?
Just I want to clarify one thing, Rashid. There is some confusion perhaps. They have filed a rejoinder. The application earlier was that one application was filed for additional evidence. During the period of Corona, something happened, they did not file their rejoinder, and the order was passed.
That's right.
Now, after remand lordship, they had filed their rejoinder. On rejoinder lordship, this order has again come.
Yes.
I fail to understand what is this rebuttal evidence. Whatever will happen, lordship, this order will now finally merge with the trial court's order.
That's right.
And whatever happens, that all the points can be taken in the appeal itself. What kind of rebuttal is required after rejoinder is already there?
You filed your rejoinder?
Your Ladyship, that's what Your Ladyship will take my IA.
Yes.
Yes, that rejoinder was filed, and that rejoinder was with respect to their evidence being admitted or not admitted. So I did not oppose
Where
four
is
evidence.
Where is
four
your
evidence.
rejoinder?
That rejoinder is not on record. I did not oppose. I opposed only the four. There were four evidences. So I said 3 are certified copies of public documents. You can take it. Fourth one should be admitted with objection. So that's what the court did. After the court admitted their evidence, I am entitled to rebut. And that was the opportunity which was intended to be afforded. So what I did is I filed an application for that purpose. That gave me an opportunity to file my rebuttal evidence. So what the court did is, court took the application and returned it back to me. Please take paragraph 5 and 6. And the hurry was because that was the last deadline on which the court was, this Honorable High Court had said that the matter will be listed before High Court. आइए paragraph 5.
You see, there was an order to pass an order with respect to the additional evidence. Whether it should be admitted or it should not be admitted.
Yes.
Right?
Yes.
Okay.
That has
So
been done.
that has been done. You have no grounds.
Now in appeal I am pointing out
Now, therefore,
that likewise I must.
You see, the trial court was confined to the direction of this court.
Exactly.
Right?
That's not the correct approach on part of the trial court.
No,
he was
that is
required
the
to follow the direction of the court. That's all right.
No, that's
but
right.
the law will take its own course.
The case is pending before this court. Now the point is that this additional evidence has already been placed on record.
Yes.
If you want to give any additional evidence pursuant to the additional evidence which has been placed on record, you have to file an application here. Not
So
there.
Your ladyship, if the trial court had in its order said, and your ladyship had said this to me.
No,
Please
no.
recollect.
I will not recollect anything over and above whatever is there in the order. I can't recollect. There are so many cases coming up. I'm only concerned with my order.
I bow down, your ladyship.
If you want to lead any evidence, right? Because of these additional evidences, you have to file an application here for additional evidence, and then I will remit it back.
If recorded,
Ladyship.
if
you
I
want-
don't join issues. I don't join issues. Take
It's
that
very simple.
if it
Yeah,
has been
let me
recorded.
just point it out for my satisfaction, your ladyship. What happened is, in the previous order which was passed, which your ladyship will find on record. May I invite your ladyship's kind attention to
Yes,
the previous
yes.
order which was set aside by your
Yes,
ladyship?
yes.
Yeah. That order was dated 24th of May 2021, which your
Yes.
ladyship will find. The entire order sheet is before your ladyship by way of NCR, but for convenience, I had also filed it by way of a supplementary affidavit which was considered by your ladyship earlier. Supplementary
You see, I
affidavit
will
dated
only-
30th of January 2023.
You
In that
please.
previous order,
It's all
which was
beyond
set aside by
scope.
your ladyship, there was an observation. The defendant shall have liberty to rebut the same by submission of documentary evidence. Your ladyship had said to me, "You
No,
order
no.
pass किया ठीक है आपको opportunity तो देगा." But then it was appreciated by your ladyship.
Rejoinder.
You see,
Objective नहीं है।
Vishal ji, I'm
You
appearing online, so please have
you
mercy on
read,
me.
you read straight away. Para, you can read para number
Which order, your
14,
ladyship?
15
Lordship's
onwards. 14 onwards
Pardon,
of the
pardon.
order passed by this court.
Okay, 26th of March.
Yes, my finding and direction, everything is there from para 14 only.
Yes. Therefore,
You
I'm not
you
saying
read
that.
it, please. You read it.
Sorry. Paragraph 15.
You read whatever you see.
This is paragraph
14.
15.
Para
This court is of the
14.
considered view that the order
14,
dated
14,
24th of May 2021 has
14.
been passed without giving any opportunity to the
Mr.
defendants.
Neeraj, para 14.
14, sorry. This court finds that the proceeding of the learned trial court is not proper and cannot be sustained on account of many reasons. Firstly, there are two contradictory orders drawn on 25th of May. First, indicating that no steps were taken and deferring the matter for argument on 16th of July. And second, indicating that the plaintiff was heard virtually on the petition dated 10th of March 2021 to admit and mark additional evidence. Further, the order dated 24th of May 2021 records that though given opportunity, no rejoinder was filed on behalf of the defendants. However, the entire order sheet does not reveal that the petition dated 10th of March 2021 seeking to adduce additional evidence was ever served upon the contesting defendant number 1, in spite of the fact that the order sheets clearly direct the plaintiff to serve the petition to the defendants. But there is no indication in the order sheet that such petition was served. This all happened during the lockdown period arising out of COVID-19 situation, and admittedly during this period, the litigants as well as the advocates were restricted from physical participation in the court proceedings. This court further finds that ultimately the impugned judgment has been passed. This court is of the considered view that the order dated 24 May 2021 has been passed without giving any opportunity to the defendants to respond to the petition dated 10th of March, and consequently, the order dated 24th of May 2021 whereby the additional evidence of the plaintiff has been admitted cannot be sustained in the eyes of law. This court is of the view that the way in which the aforesaid order has been passed by the learned trial court, the same cannot be sustained in the eyes of law. This court is of the considered view that additional evidence which has been taken on record by the learned trial court has not been taken in accordance with law, and accordingly a fresh order is required to be passed. On the point of additional evidence, a needful be done by the trial court within stipulated time. However, having recorded the aforesaid finding, the same may not be a reason to set aside the impugned judgment and remit the case to the trial court, to the learned court. Learned counsel for the respondent number 1 plaintiff is rightly referred to provisions of order 41/25 of CPC. This court is of the view that the additional evidence sought to be led before the learned trial court has a bearing in connection with the question of fact, and therefore the learned trial court is directed to pass fresh order on the petition dated 10th of March upon service of the petition along with the enclosures thereto to the defendants, and consider the same in accordance with law, and return a finding before this court within a period of 3 months from the date of appearance of the parties. The appellant and the plaintiff to appear before the trial court by filing fresh wakalatnama on 30th of April 2025. On the date of appearance before the trial court, the plaintiff is directed to furnish 5 sets of petition along with its enclosure, which will be available for the defendants to take it from the record of the court itself. So far as the other defendants who are not appearing before this court are concerned, court shall issue notice to them for appearance. Post this case on 27th August.
That's it.
Now on 27th August, the learned trial court takes up the petition there and passes the order.
That's right.
No,
With
that-
which you are not agreed by that.
I'm
You say that you have to give your evidence in rebuttal. For that you have to file a petition here. Not there.
Your Ladyship,
That was the limited direction for taking additional evidence of the
if
respondent.
already my submission is this, Your Ladyship, that if I am able to demonstrate to the court in appeal that I have not been given an opportunity to adduce rebuttal evidence, Your Ladyship is straight away remand without those evidences having been filed here.
Once you file a petition, I will see what is to be done. You can't dictate.
No, there is no question of dictating. I said I started with by saying submission. There is no question of dictating.
So
It's a submission.
there
I filed a
there
petition.
there is no petition before me.
Yes, there is an IA 14345
For what?
of 2025
For what?
for passing an order granting opportunity to the appellant of adducing evidence or discarding the evidence adduced by the plaintiff number 1.
For adducing evidence.
Yes. So that can be done
Or discarding the evidence.
by exercising the same powers which were exercised by the court earlier in favor of the plaintiff. That's a submission which I am
So
making.
the point is that now you want to adduce additional evidence pursuant to the additional evidence which has been filed, which has been taken on record on behalf of the respondent. Right? So for that purpose also you will have to place on record as to what additional evidence you want to be taken
That's
on record.
that I leave it upon your ladyship. My humble submission as a lawyer, I am saying this. This can your ladyship may remand the matter for giving me an opportunity to be done by the trial court even without evidence being there
Just
before
a
the court.
moment. You can place on record before this court what all documentary evidence, what all oral evidence you want to adduce. Then I will pass an order on that. Because it cannot be mechanical like this. There has to be
Your ladyship may
something.
fix a time frame within which
No, first-
I should adduce whatever evidence I want to adduce.
First
Your
you
ladyship may
have
give me
to, just a moment. First you place it on record, what all evidences, additional evidence you want to place on record. I will remit it for that evidence. There is no problem about it. But just because you file a petition, that is not sufficient. Only documents have been placed on record, right? Out of that, 3 documents is admitted document. So whatever, suppose
whatever it be, ladyship, what happens is the fact of the matter is that none of the two parties up till closure of evidence had adduced any documentary evidence. Defendant was entitled not to because the plaintiff had not.
that's
If the plaintiff doesn't prove a case, I am entitled not to disprove it.
that's
So when he adduced no evidence at all, I also did not adduce any
fair
evidence.
enough.
Then the matter was closed.
I think
Then
it's
they
all beyond
filed an application for
You
additional
see,
evidence.
let's not waste time on this. I am just telling you the very simple remedy. Whatever, if you want to adduce to oral evidence, if you want to adduce further documentary evidence, because you have to now rebut these evidences, you place it on record and I will do the needful notice, whatever is to be done.
Ladyship.
But you have to put it on record. It cannot be mechanically rebutted like that. That's
Okay, I was only trying to avoid a burden which
No,
falls
that is
upon me
not a
to do
burden,
it
but you
here.
have to do it. देखिए. Do you want to press this IA or not? You have an option. You can not press it and file an appropriate. That liberty I give.
But then this application will stand dismissed in that event.
Actually, I give you a liberty, no?
It may be kept pending for the time being. Your ladyship may consider both at the same time.
Not.
There is no harm in doing that.
Ground they want to take in a
There is no harm in doing that.
You see,
My learned friend's
Just-
approach I don't understand. He
just-
doesn't want me to adduce evidence in reply after he has adduced evidence.
you go outside the court and fight. That would be better.
I just want
No,
to say
outside you don't fight.
any IA I'm not objecting anything.
Outside we
You
can't
can
fight.
find numbers of IA.
You see, I tell you, you file consolidated IA, include whatever, you can include whatever you have mentioned here also. There is no
That is
problem
what I'm
about it.
submitting.
But there is, I can just observe that or if you want, I will reject it, whatever. Because this kind of petition is not sufficient. You have to at least disclose what you have to say, and then I will direct the court to record the evidence and send it back.
All right.
So what's your choice?
I would like to file a fresh IA which will be inclusive of whatever I have stated here.
Whatever. You can file it fresh. I will just keep it open to you, whatever you want to find.
But then this dismissal should not come in the way of
It will not.
raising the same contention again.
It will
in the
not.
next time.
It will not.
I completely rely upon your ladyship's wisdom too.
I will record it.
All right.
IA number
Please.
14345 of 2025 in FA number 1 of 2022. The interlocutory application has been filed for granting opportunity to the applicant for reducing additional evidence. The learned counsel submits that. The learned court has taken additional evidence on record pursuant to order dated 26/3/2025.
These will not be additional evidence, Lordship. These are primary evidence, already marked exhibit.
No, that order
We'll
got
see
set
that.
aside.
We'll see that. Yes.
The word additional evidence will, that will.
It was
Just
additional evidence in addition.
We'll see that.
How additional evidence?
What was originally accused was a nullity.
Just a moment. Thoda shant. The learned counsel for the petitioner has submitted that. For the appellant has submitted that fresh order on additional evidence was passed by the learned trial court pursuant to order dated 26/3/2025. And therefore, the appellant is entitled for adducing additional evidence. In rebuttal. However, from the perusal of and for that purpose, the interlocutory application has been filed. However, from perusal of the interlocutory application, nothing has been disclosed as to what additional evidence the appellant is seeking to adduce. And in absence of that, what additional evidence the appellant is seeking to adduce. To this, the learned counsel for the appellant submits that he may be permitted to withdraw this interlocutory application and he shall file a fresh one disclosing the additional evidence he wants to adduce. To the aforesaid prayer of withdrawal and filing a fresh petition, the learned counsel for the respondent has no objection, but he submits that if a fresh IA is filed, he shall file a response to the same, which can be considered on merits. In view of the aforesaid prayer made by the learned counsel for the appellant, the IA number 14345 of 25 is permitted to be withdrawn with the liberty to the appellant to file a fresh one, inter alia including the additional evidence which the appellant seeks to produce. कब देगा?
Leadership 6 weeks का time दिया है.
It is already there.
Any point where numbers of point.
Inter alia including. समझ गए? Legal term को थोड़ा समझिए. कितना टाइम चाहिए आपको?
6 weeks दिया है.
Too much Lordship.
Post on 11th May.
Obliged.
Item 5, FA 322
Your Ladyship, could it be on 12th, please?
Okay, 12th.
Obliged.
Yes, please.
There was an upset matters there.
Whereas not the problem 166 was of the plaintiff, plaintiff was point.
You have also filed it some.
No, I've completed it.
Is it complete? Is there any other party to file it?
No party, but there are certain judgment which I wanted to apply.
ये तो उस दिन भी आप बोले थे.
हाँ नहीं तो सर मेरे घर में डिफिकल्टी हो गया कि my mother got fractured in the leg.
तो आपको कब चाहिए? ऐसे हम आधा पर्दा चीजें बोलेंगे. आपको कब चाहिए?
Allah.
The learned counsel for the parties are present. The learned counsel for the respondent has submitted that on account of personal reasons he could not file the short synopsis of argument along with the judgments which he seeks to rely upon. He submits that the matter may be posted next week. हम लोग फर्स्ट अपील का डेट
Wednesday or Thursday.
post on next Wednesday. The written submission should be filed latest by Monday. नहीं फाइल करिएगा तो हम नहीं लेंगे.
नहीं हम कर लिए हैं खाली एक दो चीज लास्ट में डेफिनेशन
प्रीवियस वाला लेडी से
Tuesday हो गया है. कहाँ है वो? कोई बात नहीं, वो Tuesday को आएगा तो Wednesday. थोड़ा ध्यान रखना है.
Item 6, first appeal 62 of 2024.
This is part of the batch. Some matters to discuss.
I've is it covered?
See, I want number and PDR.
It is out of the same batch?
Yes.
With permission, one judgment on the record. Same laws are related.
Arising out of the same batch?
Other had same law.
सेम गांव का है. कब का है एक्विजिशन? नहीं लैंड एक्विजिशन कब का है? सेक्शन 4(1) का नोटिफिकेशन कब का है?
Year भी same.
डेट बताइए. 3/2/2006 4(1). इसमें कब का है? ये है इनका सेक्शन 6 है 14/5/2005 का. आपका सेम नोटिफिकेशन नहीं है. रादर ये वाले केस में, आपके वाले केस में जो है, जो ये जो सारा बैच हम लोगों ने डिस्पोजल किया है उसका नोटिफिकेशन पहले का है. पहले का है. You just have a look at it. इसका नोटिफिकेशन है 2005 का. सेक्शन 6 है 14/7/2005 का. सेक्शन 4 तो उसके पहले का होगा, है ना? इंटरनल पेज 5 में दिया हुआ है. इट इज नॉट द सेम. सेम गांव का होना है इज नॉट सफिशिएंट. सेम नोटिफिकेशन भी होना जरूरी है ना. इज नॉट अराइजिंग ऑफ दिस. यू वांट मी टू कंसीडर दिस? इसका कोई रेलेवेंस नहीं, वैसे हम करते हैं क्योंकि FA number 62 of 2024 heard the learned counsels appearing on behalf of the parties. आपका क्या नाम है? इस केस में आप थे? इस केस में आप थे ना? The learned counsel for the appellant has submitted that arising out of the same batch of cases, the learned counsel submits that as per the impugned judgment, numerous cases were taken up together for disposal, which were arising out of the same land acquisition proceedings. Out of them, all other cases except the present one.
There is a batch.
One more batch.
Yes.
Out of them, a few cases have been disposed of by this court in first appeal number 48 of 2024 and other analogous cases by judgment dated 16/9/2025, whereby the same has been disposed of in same terms as first appeal number 594 of 2014 and other analogous cases by reducing the compensation from rupees 3238 per decimal to 2403.67 per decimal. The learned counsel has also submitted that the order passed in first appeal number 596 of 2014 has also been placed on record in this case,
Annexure 1.
which is Annexure 1, which has been followed in first appeal number 48 of 2024 and other analogous cases. He submits that the case is squarely covered by first appeal number 48 of 2024 and other analogous cases. The learned counsel for the respondent does not dispute that the present appeal arises out of the common judgment passed by the learned trial court, which was subject matter of first appeal number 48 of 2024 in relation to the same village. However, he submits that, he has referred to judgment passed in first appeal number 190 of 2015 and submits that with regard to the same village, the grant of compensation at the rate of rupees 3238 per decimal has been upheld. To this, the learned counsel for the respondent, for the appellant, has submitted that the Section 4 within bracket 1 notification in FA number 190 of 2015 and other analogous cases was dated 3/2/2006 and in the present batch of cases being first appeal number 48 of 2024 and other analogous cases, the section 6 notification dated 14/7/2005 was published on 1/8/2005, and certainly the section 4 notification preceded the section 6 notification, correct? You submit that the date of notification in FA number 190 of 2015 being subsequent to the date of notification in FA number 48 of 2024, the higher rate of compensation mentioned therein cannot be compared with the present case. Apart from the aforesaid distinguishing feature, no other after hearing the learned counsel for the parties, this court finds that a batch of land acquisition cases were disposed of by the learned trial court by common judgment dated 30/11/2022, all relating to the same village,
Yes.
all relating to the same village, namely Tuppa. Where do I get this?
Page 4 of the judgment.
Namely village Topa, PS Mandu, Thana number 126, wherein large chunk of 116.54 acres was acquired at one go, for which notification under section 6 was issued on 14/7/2005, published in the official gazette on 1/8/2005. The present case arises out of award number
93.
award number 93 of 2012. ना आपका कटिंग है पैरा 1 में, बहुत ज़्यादा कटिंग है. It is, you just give me the case number. Award number 93, 93, dated 13/12/2022 in LR case number 450 of 2012, arising out of LR case number 06 of 2005-6. The case is squarely covered by the same judgment. So far as the judgment which has been relied upon by the respondent is concerned, the date of notification is of the notification under section 4(1) of Land Acquisition Act 1894 is dated 3/2/2006, which is subsequent to the notification involved in the present case, and accordingly the said judgment has no bearing in the present case. In view of the aforesaid facts and circumstances, this appeal is also disposed of in same terms as first appeal number 48 of 2024. Paragraph कौन सा पैराग्राफ कोट करेंगे? और भी तो बहुत सारे केसेस डिस्पोज किए हैं ना. Which paragraph of this first appeal is to be quoted? Para 16 onwards. Is there any error in paragraph numbering? How is para 16 repeated in page number 13?
Page 13 is para 16 and 17.
Yes, para 16, and there is para 16 in page number 9 also. Isn't it? There is error in para numbering. सौरभ आपकी कहा है जजमेंट में there is an error in para numbering. The last page, para number 16, page number 13 से बोल रही हूँ till the end, right? Your appearance is to be recorded. हाँ, इनका appearance. हाँ, दोनों का appearance. He referred to some other judgment where the date of notification is of 2006. Here the date of notification in view judgment में it is referring section 6 notification. Section 4 तो पहले ही हुआ होगा. ठीक.
इसी बैंक से दो
और बाकी है.
नहीं बाकी और नहीं है.
इस बैच पे कुछ बाकी है.
एक और बाकी.
कहाँ है वो? 29/4. आप हैं उसमें?
Item 7, first appeal 159 of 2024.
हो गया.
Item 7.
Yes, why do you need time? Sir, क्या matter है?
Which matter about the cancellation of two sale bids. They are so concerned with
With consent date fixed हुआ है.
they are yesterday also.
Sorry?
Yesterday we get two consent from me, so therefore I.
तो दोनों के कंसेंट से 10-20 साल एडजर्न कर देते हैं, क्या दिक्कत है?
हमको
दोनों कंसेंट में रहिए.
After the period.
कंसेंट से डेट फिक्स भी होता है, कंसेंट से एडजर्न भी होता है. कोर्ट जो है सोचते रहे कि क्या करना.
they are telling request based on non-request.
With the consent of the learned counsel for the parties, the matter is adjourned by way of last indulgence to be taken up on next Wednesday. Final disposal में है. The parties to prepare short synopsis of argument and the judgments which they seek to rely upon and file it by Monday.
Item 8, FA 217 of 2024.
Yes, please.
May this please your petition. May I be allowed to place the case before your lordship?
Where is the respondent? You are there.
May I place the case before your lordship in short? I've already provided a short synopsis of this case matter, and I've already handed over to the
Specific performance.
Yes. Suit for specific performance.
You are the plaintiff or the defendant?
I was the defendant in the original suit.
It contested, uncontested.
It was uncontested.
Uncontested.
Yes.
Uncontested and you have lost.
Yes, ma'am.
FA number
FA number is
217.
217 of 2024.
Defendant is the
Appellant here.
applicant. Sole defendant?
No.
Sole defendant? Are you the sole defendant? Defendant number?
Defendant number 1, 2, 3.
Okay. Defendants are the?
Defendants are them.
Suit was expected.
Yes. Although WS was filed, but that was not accepted. It is there in the MP note.
WS filed, not accepted. Okay. Then
May go with the brief facts of the case.
what is the date of agreement?
Date of agreement was 8/1/2015. It was between the deceased owner of the defendant number 1 and the plaintiff.
Sorry, it was between?
It was between plaintiff and the deceased son of defendant number 1. Who is the appellant number 1 here?
Deceased son of defendant number 1. What about the status of other two defendants?
They were wife and minor son. Daughter.
Why have they been made party?
They have been made party.
Why? What was the reason?
Because there was an agreement to sale by and between the plaintiff and the deceased son of the appellant.
Okay, so they are also the legal heirs.
Yes, they are the legal heirs.
Alright. When did the son die?
Son died on 9/7/2018. Agreement is of 8/1/2015.
Died on 9/7/2018.
2018. Agreement was of 8/1/2015 with the condition that the consideration amount should be paid by 7/1/2016.
Paid by 7/1/16. Not paid?
Not paid entirely. There is an admission also on the part. There was a legal reply. The plaintiff made a legal notice to the deceased son.
When?
He made that is marked as Exhibit 1, Exhibit X, dated 30/5/2018.
35/18.
that has been marked as marks 1x.
That's
To that matter, the decision had replied, it has been marked as x1, that is dated 25/6/18.
25/6/18.
In that, the decision has clearly stated that he has reputed the agreement to sale because that was not.
No, but your written statement was not taken, no?
No.
So your stand will not be taken from your legal lawyers, right? What is their case in the exhibit? So
they
what?
have exhibited that particular document also.
That's right. They
And
have
I'm talking from
exhibited.
that document only. That is exhibit X1, wherein reply to the legal notice filed by the plaintiff, the
What
decision
is the
has
finding on readiness and willingness?
my let's may kindly have, that is a very essential part which needs to be seen by this honorable court. The finding is at page number 40. Merely statement has been mentioned. May I read
Page number 14.
page number 14. Issue has been framed at page number 7. There are 5 issues which has been framed by the London court below. 6 issues, I beg your pardon. 6 issues has been framed. 2 issues are relevant on which this judgment and decree has been passed in favor of the plaintiff. That is issue number 4 and issue number 5. May I read that issue number 4 and 5, which is at page number 7 of the judgment.
Issue number 4 and 5.
Yes.
There is no issue on readiness and willingness?
No. And there was no such document adduced by the plaintiff in the entire suit that he was readily and willing to comply the conditions of the said agreement to sale. And finding also, my lords, may kindly have the findings. Findings, specific findings is at page number 15 of the judgment. First paragraph. Has you got it?
Just a moment. Para number 8, the finding starts.
Yes.
Right? Let's have a look at it.
Maybe, or I'll just go to the important paragraph.
Just a moment.
In page number 14, towards the last paragraph, and page number 15, something has been stated with respect to readiness and willingness. Only statements.
When did he die?
The
9/7/18.
yes, 9/7/18, and even the claim was filed beyond the period of limitation, because the period of limitation was to be calculated from the date it was extended till the date it was extended. The agreement to sale. That was 36/2008, 36/2016. The present appeal has the present suit was filed on 26/9/2019. That is beyond 3 years, and the limitation for filing such kind of
Limitation
suit
issue has not been
considered.
not been
Not been
framed
framed,
also.
not been considered. Both.
Yes, क्या बोलना?
I am relying on 2 judgments of the Honorable Apex Court regarding the readiness and willingness, as well as onus of proof for the plaintiff to prove the case.
Plaintiff not the plaintiff has specifically about each and everything, and he has said on each and every point that he is also ready.
How is the readiness and willingness? What was the balance amount of consideration to be paid?
15 lakh already paid, 38 lakhs
Was to be paid.
Yes,
Remaining.
20 blood
23 lakhs.
38 lakhs.
23 lakhs. Sorry, how much was paid? What was the total consideration?
30 lakhs, 38 lakhs
50,000.
Total consideration 38.5 lakhs.
Yes,
50 lakhs. 50,000.
yes.
Paid how
15
much?
lakhs.
15 lakhs.
15 lakhs.
Remaining is 23 lakhs and 50,000.
Remaining 23.50. What are the basic ingredients for readiness and willingness?
Lord, there are two things, Lord. In the plaint itself, I have said, kindly Lord have.
Plaint से नहीं होगा ना?
Plaint
Evidence
से दिखा रहे हैं, Lord. Because Lord, even they have not come with any evidence. They have given Lord series of chances.
आप
for
हमको जरा ये बताइए, what is the, how does a person prove readiness and willingness?
Lord, that is Lord the steps he has taken, and from the Lord contents of the plaint, that is need to be considered Lord when it is uncontroverted, and Lord that is if it is uncontroverted,
No.
and Lord each and every time
Readiness
I
and
have been,
willingness, you also have to, willingness is, yes, it's okay. Your conduct will show the willingness. But readiness, where is the money?
Lord I have said Lord.
Where is the money?
money
As
I
per
have-
your plaint, where is the money? As per your plaint.
Yes, Lord, I have said. And in
Your mere statement is not sufficient.
but Lord, since it has not been controverted,
No, that is not the law. And other law is that the court has to frame specific issue on readiness and willingness.
Lord,
There is
they
no
have-
such issue framed.
but they have never participated in
Need
the
not.
proceeding, Lord.
Merely because they do not
And the court has
participate.
given a finding on this issue with respect to readiness and willingness also, my Lord. And Lord, one point, Lord, that each and every time the the plaintiff has given notice to the other side. They
You
have
say
never said,
the sale was to be executed when?
It was to be executed. It was executed by and between the deceased son of appellant, defendant number 1 and the plaintiff. It was executed on 8/1/2015.
8/1/15,
Yes, with the
date of
condition-
agreement.
Yes, with the condition to complete that agreement to sale by 7/1/2016.
7/1/16.
Yes.
Right.
It was extended. It is at admitted position. It was extended till 30th of June 2016.
2016 extended.
Yes. Thereafter, nothing.
Just a moment. When was the suit filed?
Suit was filed in the year 2019. That is
Date.
specific date is 26/9/2019. As per the plaint I am mentioning. That is beyond the period of 3 years.
And which is that judgment you are relying upon?
I am relying on two judgments. One is Ravi Setia versus Madan Lal. Paragraph 13 and 14 are relevant. May I read that part of the judgment? It has specifically dealt with readiness and willingness, and merely statement with respect to
And
readiness.
the other one?
Other one is His High Holiness Acharya Swami talks about readiness and willingness.
No, but on limitation you are not.
Limitation. One more judgment with respect to burden of proof.
इसका पैरा कौन सा? आचार्य
Justice.
पैरा 2.
Para 2.
What all judgment? What other?
And one more is Anil Rishi versus Gurbakshi. That is para.
Citation.
Citation is 2006, volume 5, SCC 598. It is on burden of proof.
Para number
Para number 10, 19,
10, 19.
and 8.
ये उल्टा चल रहा है क्या? 10, 19 and 8. 8, 10, 19.
I beg your
This is
pardon.
on burden of proof.
Yes, it is on burden of proof, which primarily rests on the plaintiff when the suit is filed.
Where is that? Which is that judgment? One has to assert the availability of money. Which
Ravi-
is that judgment?
Ravi CPS,
Okay, place this judgment.
paragraph 13.
Read it,
May I
please.
read one? Paragraph 13 in Uma Bai versus Nilkan.
It is referring to some other judgment.
Yes, it has referred to one more judgment. It is now well settled that the conduct of parties with a view to arrive at a finding as to whether respondent plaintiff were all along and still are ready and willing to perform their part of contract as is mandatorily required under section 16C of Specific Relief Act must be determined having regard to the entire attending circumstances. Bare averment in plaint or statement made in examination in chief would not suffice. this is what the case of the plaintiff is.
You have still not got hold of the correct judgment, where the availability of the fund is also required.
That has been dealt in Holy Acharya Vargamani.
But
Paragraph 2 maybe.
yes, please.
At the bottom, whether the court may infer from the facts and circumstances whether the plaintiff was ready and always ready and willing to perform his part of the contract. The fact of this case would amply demonstrate that the plaintiff petitioner was not ready nor had the capacity to perform his part of the contract as he had no financial.
No, not this. Not this. अपने कोर्ट का जजमेंट नहीं पढ़ते हैं क्या? कम से कम कई केस तो हम ही डिसाइड किए और रेडीनेस एंड विलिंगनेस. Availability of fund is an issue. One has to avert it, if not deposit it. At least the source of fund
Source
has
of
to
fund
be
has to
disclosed.
portrayed, disclosed before the
In your plaint, have you disclosed the source of fund?
Lord, I have in the evidence also, in the depositions also. I have
Source
said-
of fund.
Yes, Lord.
What is your
I
source
have-
of fund?
I have not the SOPs, dealing with Lord with the Lord SOPs. I have the SOPs with all the oaths and other things, Lord. I have the sufficient capability, Lord.
No,
I
not
have all the-
capacity.
Yes.
Not capacity. Availability of fund is that it should be available with you. What is the source? You must be a multimillionaire. That is not
Lord,
sufficient.
one judgment on the basis of which, Lord, I am saying that Supreme Court has dealt, Lord, in 2017, 2000, Lord, I have the judgment also, in which it has been said. I have one copy, Lord.
Yeah.
Lord, para 24, Lord.
Yes.
The expression readiness and willingness has been the subject matter of interpretation in many cases, even prior to the insertion of section 16C of the specific fact. While examining the question as to how and in what manner the plaintiff is required to prove his financial readiness so as to enable him to claim a specific performance of contract, the Privy Council in his leading case, which arose from the Indian courts, so and so, approved the view taken by Chawla ACJ and held inter alia that it is not necessary for the plaintiff to produce the money or vouch a concluded scheme for financing the transaction to prove his readiness and willingness. The following observation of the Privy Council are apposite. Their lordship agree with the conclusion and grounds on which it was based. It is true that plaintiff one stated that he was buying for himself and he had not sufficient ready money to meet the price, and that no definite arrangement has been made for finding it at the time of repudiation. But in order to prove himself ready and willingness, a purchaser has to necessarily to produce the money or to vouch a concluded scheme for financing the transaction. The question is of one of the facts. In the present case, the appellate court has ample material on which to find the view it reached. Their lordship would only add in this connection that they fully concur with Chawla ACJ when he said, in my opinion, on the evidence already on record, it was sufficient for the court to come to the conclusion that plaintiff one was ready and willing to perform his part of the contract. It was not necessary for him to work out actual figure and satisfy the court with what specific amount a bank would have advanced on the mortgage of his property and his pledge to this heir. I do not think that any jury, if the matter was left to the jury in England, would have come to a conclusion that a man in the position in which the plaintiff was not ready and willing to pay the purchaser price of the shares when he had brought from defendant number 1. From the foregoing reasons, their lordship answered question 4 in the affirmative. This court in Sukhbir Singh versus Brijpal Singh followed the opposite principle with the word. Law is not in doubt. It is not a condition that the respondent should have ready cash with him. The fact that attended the sub-registrar office to have the sale deed executed and waited for petitioner to attend the office of the sub-registrar is a positive fact. to prove that they had necessary fund to pass on consideration and had with them needed money with them for payment at the time of registration. It is sufficient for the respondent to establish that they have the capacity to pay this sale consideration. It is not necessary that they should always carry the money with them from the date of suit till the date of decree. It would therefore be clear that the courts below has appropriately exercised their discretion on granting relief of specific performance to the respondent on the sound principle. And keeping this broad principle in mind, we are now clearly will settle. Let us examine the facts of the case. Thereafter, the facts have been dealt with. The positive statement, the positive I have not on the basis of the plaintiff, I am saying not that I have issued the notice for compliance for execution of the agreement. Thereafter, my lord, he was murdered, and thereafter waiting for only 40 days. In the suit, my lord, I have already mentioned all these things. In the suit also, I have given a notice to them after death of the sole person with whom I have entered into agreement. I have waited for 40 days, and thereafter again I have issued notice to the legal heirs of those persons.
You see, just a moment. The agreement was to be executed by 30/6/2016.
Yes.
He expired on 9/7/2018.
Yes.
What have you done from
Lord,
30/6/2016 to
Lord,
9/7/2018?
several times I have went there. Lord, since what has happened.
Several times means what date? What
Yes, Lord,
details?
I have given you. I have given Lord in the facts also, in the judgment, in the Lord evidence also. Kindly have Lord the facts of the plaintiff.
He specifically that. This is the plaintiff.
And what they replied, both two things they have admitted. They have admitted the agreement, they have admitted the amount which
No, it's ex parte, everything is admitted.
No, Lord, even in that notice also they have given. An ex parte, Lord, it is not the first time it is ex parte, Lord. They have participated in the proceeding, and thereafter, after appearing for certain days, Lord, they have again
That's why the written statement was not accepted.
Lord, but they have filed and they have never pressed that. Lord, I will
That's
give
right.
the list of dates.
You see, the proceeding is ex parte.
Lord,
So your evidence has to be seen. We are not bothered about what they did.
If the evidence is not ex parte, then Lord, they have the alternative remedy under section order 9/13.
No,
They
no.
should not have come before this court.
No,
It was
they are not agreed by that the proceeding is ex parte. They say that the plaintiff has not been able to prove his case as per the requirement of law. That is their case. And it is very surprising that the court did not even frame an issue on the point of readiness and willingness.
Lord, readiness and willingness that has been I will
But dealt with is another thing. The court is required
that is already Lord, since there was no contradiction.
Okay.
Therefore, Lord, those issues cannot be specifically framed. The contradiction was not there. They have not participated in the proceedings.
You read para number 8
of the
of the implement.
Lord, prior to that, Lord, I need to Lord, refer to this Lord, late of the.
Okay, that's good. Thank you.
First paragraph.
आप लोग इतने मतलब कितना 7-8 साल पीछे क्यों चल रहे हैं? कितना 25 में 23
25 का भी judgment.
There are so many judgments on this specific relief act, readiness and willingness. कितना पीछे?
This judgment, Lord,
आपका enrollment कब का है?
25 का judgment Lord, latest in.
देखिए हाँ प्लेंट में बताइए क्या बताना चाहते हैं?
So first paragraph, I have given the details of the property and how.
That's why there is no dispute on that. There is no dispute. Readiness and willingness का paragraph की
Lord, paragraph 5. That the total payment made by the plaintiff to Sajad Khan was 15 lakhs, only to different dates and time, detailed and described in Schedule C of this plaint. That the plaintiff repeatedly requested Sajad Khan to accept the balance consideration amount and to exclude the sale deed in favor of the plaintiff for the aforesaid land. But Sajjad Khan avoided the same on one pretext or the other and evaded the acceptance of money and exclusion of sale deed. Plaintiff also personally went to him and asked for the same. Sajjad Khan also told the plaintiff that whenever there will be need of money, he will ask plaintiff and plaintiff has to pay. The plaintiff also sent legal notice dated 35/2018 to Sajjad Khan for performing his part of the contract by accepting the balance due consideration amount and by excluding the sale deed of the aforesaid land. That on 25/6/2018, Sajjad Khan gave reply to the legal notice of the plaintiff, accepting the contract between him and the plaintiff and also accepting the advance received by him as part consideration price of this contract. Further putting false allegation on plaintiff just to avoid exclusion of the sale deed and performing his part of. Suddenly and unfortunately on 9/7/2018, Sajjad Khan was shot dead by some unidentified persons at Balmil district, Hazaribagh, near his residence. That due to sudden incident in the family, the plaintiff waited for 40 days as per custom and rights of the Muslim law and then approached defendant number 1, father of Sajjad Khan, now deceased, and showed him the agreement executed by his son and the plaintiff. The plaintiff further requested defendant number 1 and 2 to accept the balance due amount under the agreement for the sale and to perform the exclusion of the sale deed as per the law, which the defendant number 1 and 2 outrightly denied the contract agreement agreed between his son and plaintiff and further denied the exclusion of the sale deed. That ultimately plaintiff again sent legal notice to the defendant number 1 and 1 to 5 for performing their part of contract and further to exclude the sale deed in favor of the plaintiff after receiving the due balance amount. That defendant number 1 to 5 replied on 11/6/2019 to the legal notice sent by plaintiff, denying all the facts and circumstances. They denied the existence of such land in the name of Sajjad Khan. Now, on different aspects, not they are denying. And so, neither Sajjad Khan has entered into any such agreement with plaintiff, nor he received any sort of advance money from the plaintiff, nor he was capable.
They denied the title of Sajjad Khan.
They were even denied the title of it. That the plaintiff is always ready and willing to perform, and is still ready and willing to perform his part of the contract. But the defendants always referred the matter one pretext or the other and had also avoided the same. That the cause of action for the suit arises.
How many witnesses were examined?
4
from your end?
witnesses available.
And where is the plaintiff?
Defendant number 4.
PW4?
Yes, PW.
Nikhil sir.
Married.
Just a moment. Yes.
So there are 4 witnesses.
PW4, you just read PW.
Yes, yes, ma'am.
That has been indexed with the first memo of appeal also. Starts from page number 39.
इसका oral evidence कहाँ है? इसमें एक और बंद होगा. निकालिए oral evidence कहाँ है? इसमें लगा हुआ गुलाम हुसैन
Yes,
इनका क्रॉस एग्जामिनेशन
but they have not processed.
अच्छा हाँ फिर कोर्ट क्वेश्चन भी नहीं है कोई There is no court question also. Okay. क्या पढ़ना चाहते हैं इसमें बताइए. Which paragraph do you want to read?
That not यह कि मैं लोहे का ग्रिल बनाने का इत्यादि बनाने का काम करता हूँ. मेरे दुकान
लोहे का ग्रिल बनाते हैं.
Yes. यह कि प्रतिवादीगण को जानता हूँ पहचानता हूँ. यह कि प्रतिवादीगण के पुत्र शाहजहां खान ने किया प्रतिवादन किया सो एंड सो with respect to mirror or yes.
You just come to readiness and willingness. ये जो एक कारानामा की अवधि जो बड़ी है 36/2016.
Yes.
Is it by a written document?
It was extended in the agreement itself by the disease.
Para 8. यह कि बकाया राशि 23,50,000 लेकर मैं शाहजहां खान के घर गया तथा उससे जमीन के वाला रजिस्ट्री करने का अनुरोध किया तो शाहजहां खान जमीन बिक्री करने में आनाकानी करने लगा तो मैंने अपना अधिवक्ता के माध्यम से शाहजहां खान को वकालतनामा नोटिस दिनांक 30/5/2018 को भेजा. उक्त वकालतनामा नोटिस मैंने वकील साहब का तथा मेरा हस्ताक्षर है. वकालतनामा नोटिस मैं इस पर अंकित करता हूँ. यह कि शाहजहां खान ने मेरे अपने अधिवक्ता के माध्यम से दिनांक 25/6/18 को मेरे वकालतनामा जवाब भेजा. इसका जवाब 4 पन्नों का है. जवाब में मैं शाहजहां खान और उनके अधिवक्ता का हस्ताक्षर है. इसे प्रदर्श समर्पित करें.
आपके प्लेन में तो कहीं नहीं लिखा है कि उनके घर कैश पैसा लेके गए थे.
कोई डेट भी मेंशन नहीं है.
कैश पैसा लेके उसमें लिखा बट ये सेड दैट
एविडेंस में बोले कैश इतना लेके गए थे 23 लाख. लेकिन आपने प्लेन में कहीं नहीं.
Not each and everything, not in
No,
the
no,
plate.
each
I
and
have said
everything.
that,
It's a very material fact.
but in the
और
plate
ये जो
not I
आप
have
इसमें
said.
बोल रहे हैं जस्ट अ मोमेंट मरने के बाद तो आप कुछ भी बोल सकते हैं.
Not they have accepted the amount. They with respect to
That
amount.
is,
They,
the point is you say in your evidence that 23,50,000 you took cash
On which date not specified.
on firstly on which date it is not
Yes.
not mentioned. इसमें evidence में भी तो कहा.
But that there is no cross examination.
That's
It has to be taken on until it needs to be cross examined. They have not cross examined. Therefore, Lord, it has to be admitted that what I have asserted that has not been cross examined. It needs to be considered. Lord. And thereafter, Lord, 9 and 10. These are the positive steps which the plaintiff has taken. First, Lord, notice to the original Lord, the person to whom he has entered into agreement.
Where is the notice exhibit number?
Exhibit number, Lord.
Exhibit number X is a legal notice made by the plaintiff to the deceased son. And the reply is exhibit X1.
Exhibit. नहीं हमको एग्जिबिट
same thing has been referred by the deceased son in his legal reply, Alex. Paragraph 5 and 6 needs to be changed. Exhibit X1.
ठीक है पढ़िए.
जो यह कि मेरे वकील ने आपके साथ जमीन खरीद बिक्री का इकरारनामा दिनांक 8/1/2015 को हजारीबाग में किया था, जिसमें कुल रकबा 23.5 डिसमिल जमीन जिसका कुल कीमत 38,50,000 रुपया तय किया गया.
आप लीगल नोटिस पढ़े थे? नहीं नहीं हम देख लें. आप कितना एविडेंस पढ़े?
But even not in the reply. Reply is not more important. What not?
Reply is that you never contacted for payment of revenue. This is the
There are two. And there, not one thing is important. Not nowhere I have said that please return my money. Nowhere. Moreover, Lord, I have the person who is asserting, and I have the person who has given legal notice. Lord, he is a person, Lord, is Sajjad Khan. He has taken lot of loans from various persons in his area, Lord. And he was Lord here and there.
Where is the agreement of sale?
Agreement of sale, Lord, that is also
Executed.
Exhibit 1.
Exhibit 1.
Yes.
Certified copy.
Because Lord, that copy was Lord, that agreement was Lord exhibited in another case. That was Lord against him. Some criminal case was going on.
What
There-
was the nature of the notice?
Lord, that he has taken some amount from various persons and thereafter Lord some disputes arises. And thereafter Lord he was also killed for other reasons. As a witness I have been taken and that original copy of that agreement has already been taken by me. Para 2 या कि
Yes, yes, continue.
या कि मेरे लेखधारी को चाहिए कि अंदर बयान में बकाया रकम लेखधारी को वसूल पाकर वो लेख दिखाकर स्वतः लेखधारी के कथन अनुसार रजिस्ट्री के द्वारा नामी को जाहिर कर देंगे. अगर रजिस्ट्री के द्वारा करने में आनाकानी करेंगे तो लेखधारी को अख्तियार होगा कि कानूनी खतरा का से अपने नाम पर कंपलसरी रजिस्ट्री के द्वारा करवा लेंगे. अगर कानूनी कंपलसरी रजिस्ट्री के द्वारा करवाना पड़ेगा तो उसका कुल अदायगी खर्च भी देनदार मामले में लेखकारी में उत्तरदारी मान लेखकारी हैं वो होंगे.
फिर से दोबारा एक लीगल नोटिस भेजा 2019
द्वारा जब उनके लीगल ईयर्स जब रिफ्यूज कर दिए तब
and they also responded to your legal notice.
yes, they have also responded. That is also your exhibit. That is X3. Mark X3. Now they have stated different things. And Lord, my suggestion is that I am the person who has Lord, taken all the steps. I in the complaint also I have asserted all those things, and Lord, thereafter I am the person who has issued notice to them. I am the person, Lord, who has even they have replied in my in reply to my notice, Lord, they have accepted the amount and they have accepted the payment also. That is also not denied, Lord. Even Lord, after death, Lord, he was not died in between. Even legal years, I have also noticed just after 40 days, even they have replied, and then when they have refused, I have filed this this suit. And the manner in which it has been dealt. Now the plaintiff is saying that ex parte proceeding has been taken, but kindly have the manner in which it has been taken.
No, that they cannot have any grievance. Ex parte proceeding is there, they cannot have any grievance to that.
I am just trying to pursue that how many times, how many dates for not less than 4 years they have taken time on different occasions. They have appeared. They have even filed this WS also, but they have never presented again. They have again ex parte. Each and every time, they have ex parte. So, at least, some of the relevant date of their appearance from the lower court record.
No steps were taken by the plaintiff till the lifetime of the disease.
He was sometimes he has also responded for other reasons.
Why were you not appearing? Why were you not participating for 4 years?
They have participated. They have also filed.
You could have even cross-examined.
That was also barred. I was barred. The plaintiffs, the defendants were barred from cross-examination.
The defendants were barred from cross-examination.
Yes.
Since the proceeding was ex parte.
Yes.
Which is that order? By which proceeding the proceeding was set ex parte? By which order?
Order dated is 21/2023. Order to proceed ex parte was passed. Thereafter, on 8/8/2023, defendant discharged from cross-examination.
Discharged from cross-examination. And not given opportunity to cross-examine are two different things. You did not choose to cross-examine. So you are bound to be discharged from cross-examination.
Also, I have prepared.
By which order you were discharged from cross-examination?
That is 8/8/2023.
8/8/2023.
The plaintiff was to take positive steps during the lifetime of the disease symptom. And after the expiry of the extended time, the contract agreement to sale itself repudiated. And section 16 of the SRA specifics talks about no relief can be granted when there is a breach in condition.
What is the breaching condition?
They should have fulfilled their agreement to sale condition well within the time frame, the extended time period. That is 36/2018. That has not been done. And no positive steps was taken till the deceased son of the defendant number 1 died. No positive step, nothing has been stated. What steps they have taken, they have not averred anything.
They are completely silent till his death.
Yes. And the readiness and willingness is also not true.
But during his lifetime, they issued notice to him.
After?
No.
One legal notice was issued.
To which he responded also.
Yes, I have responded. And in that
No,
particular
they had responded. Your son had responded.
Yes, I have responded. The son has responded. The
Yes.
son has responded.
Yes.
And in specific paragraphs, he has categorically stated that the contract of agreement to sale is repudiated because you have not performed the consent. Yes, that is it.
Lord, in the notice which I have given, even the person who has deceased, he has also responded, but he has not denied.
The balance consideration amount was to be paid by which date?
It was to be paid by 30th June 2016 itself.
It was not there, Lord. That within a time period that it was merely extended and he was supposed to. That was there was no specific which has been mentioned in the contract.
And before that,
just a moment.
no further extension.
The sale deed was to be executed.
Agreement to sale.
Agreement of sale is 8/1.
Yes, 15.
15.
was to be done till 7/1/2016. It was to be complied. The tentative failed. It was extended upon payment of 3 lakh rupees. That is admitted position. It was extended till 30/6/2016. And
Extended till.
till
And during this period, he never offered.
never. That same
Is
consideration amount
there
never offered.
any pleading that even during this period he had come?
Only one in my reply I have stated on such and such date. And just Your Lordship may kindly have the legal reply made by the deceased son to the legal notice served by the
No,
plaintiff.
not legal reply. उससे नहीं चलेगा ना. Not that.
कोई specific government इनकी तरफ से कहीं नहीं कि on this particular date I have come with such and such amount. Nothing has been about. No date, nothing, no time, nothing has been about. And the price of the property always escalates. It's an agreement to sell it, and it was not complied well within the time frame. And then when they are in breach, they cannot ask for.
Is there any which is that clause in the agreement of sale regarding payment?
Last page 4/4 of that agreement, exhibit 1. In that they have said दिनांक इतना तक 8/1/15 तक.
When he was not, he has shown his intention. He was not ready to take the amount. Even he was just dealing with that he will be taking that amount. All those things I have already.
नहीं, आप हमको ये बताइए. You see, in your evidence and in your plaint, right? You are not stated as to when did you go to him with the money. Just a moment. पूरा question सुनिए तब जवाब. You are not stated when did you go to him with the money.
But I have stated that I have.
No date has been mentioned.
Not I.
The case has been filed much thereafter.
Not three occasions. I have said that time and occasion I have went.
Time
there.
and occasion means what?
Several times
Did
I
you
have
say
went
that during the subsistence of the agreement you went there?
there. Lord, I have
Because
said,
the agreement expired. Agreement expired in 2016. Correct?
Yes.
Right? And then you say that you time and again you went to him. Right?
after expiry, Lord, there is no assertion that after expiry I went there. Even Lord, I have said
No,
that
is
I have
there
reached-
any assertion that you have been to him before the expiry, during the subsistence of the agreement, and he was not agreeing for that? Because you have to prove your case, isn't it? You might be going to him for execution of the agreement of the sale deed, but when is important?
Lord, but assertion, Lord, in the evidence also I have given that each and every time.
No
I went
date
there.
is given.
But Lord,
When did you go?
that will not. That is not when the contradictions would appear.
No, no
It should
contradiction.
have come-
You have to give a date as to when did you visit them. In absence of that date, you will simply make an assertion that you went there time and again with cash money of rupees 23 lakhs.
One person, Lord, who has given Lord his 15 lakh rupees what he has earned, he has given Lord to a person, and thereafter Lord he is visiting. It is very
So
Lord.
therefore, if he was
He did
visiting him, right,
There is
then
nothing.
that should have been there in the plaint or the evidence.
And Lord, even in the reply, they have
Should
never
have
said
been
that that has been cancelled. They have never said there is no step which has been taken by.
They need not
that
take
the
any
agreement
step.
has been cancelled.
You see, you have to offer the money within the stipulated time. That is your primary duty.
I have said, Lord. I
And
have
also
said,
to institute suit
I have said in
within
various pleadings, Lord.
No,
and
you are
the
show
evidence
me
also-
one pleading which says that you approached them during the subsistence of the agreement, if not even a date, right? And then he refused.
in the Lord.
These dates are very important in specific performance of contract. 2015 का agreement पर आप अभी 2025 में आपको specific performance चाहिए.
नहीं 2019 से हम लड़ रहे हैं।
लड़ तो रहे हैं.
2018 से इनका डेथ हो रहा है, 2019 से हम फाइल किए हुए हैं, उससे पहले हम स्टेटमेंट दिए हैं, उससे पहले हमको नोटिस दिए हैं। They have taken my 15 lakh rupees, Lord. I am not a rich man. Though, Lord, I have given the amount, and I have also given every time I have said that I am ready and willing to perform the contract. I am always ready, Lord. और ये जो इनका जो स्टेटमेंट था या कि बकाया राशि जो पैरा 8 में लिख रहे हैं इनका, या कि बकाया राशि 23,50,000 लेकर मैं सजाद खान के घर गया.
कब?
There may not be the specific date, but he has asserted that he went there to his home. And उससे जमीन के वाला रजिस्ट्री करने का अनुरोध किया तो सजाद खान जमीन बिक्री करने में आनाकानी करने लगे.
You have also prayed for an alternative relief of refund or
That is not in alternative. I would not have proved my case. I have already proved, Lord. I think, Lord, I have presented lot of evidence, and Lord, I have presented that readiness and willingness have also been made. That the positive steps have been taken, Lord, in the judgment also, Lord, in the other judgment also, Lord, I am just placing on respect with readiness and willingness. That a positive steps have been taken by the plaintiff, not by the respondent. There is no communication on behalf of the respondents, on behalf of the defendant, to say that the agreement was already expired and you have not performed, I am not ready to do anything. There is nothing.
You can't put the ball to them.
But
You have to prove your case of readiness and willingness to perform your part of the contract as per the contract.
As per the contract.
As per the contract, you have to demonstrate.
That will not be evidence which I have not asserted. In the witnesses also, Lord, they have said, they have also said, and even Lord, I have said in the witness also, even the plaintiff also I have given, Lord, and one go, Lord, I have given this 15 lakhs through different checks. That is also mentioned. So, Lord, in one go, I have given 15 lakhs. I could have.
It's not in one go.
No, it's not in one go.
It's not in one go.
Thereafter 3 lakhs of one extension of time.
3 lakhs you had given for extension of time, and the differential amount is quite a lot.
Yes.
It's not that you must be a rich person. For you, 23 lakhs may not be much amount.
Lord, one judgment in which not only 2 lakhs have been given, in 28 lakhs, and there also Lord, the Supreme Court has not accepted that.
ठीक है, हम सुन लिया. आप लोग नोट बनाइए, परसों रखते हैं. आप नोट बना लीजिए. आपको जितना जजमेंट लगाना है सब एक साथ पैरावाइज लगा दीजिएगा. यहाँ के भी कुछ जजमेंट्स हुए हैं, प्लीज़ हमको अभी मेरे पास है नहीं तो मैं इसको अभी रिजर्व कर लूँगी. इसको मैं देखना चाहिए.
82 and 88 के लिए Lord, I have given the judgment.
और that should be sufficient.
नहीं,
ये जितना जजमेंट्स आप दिए हैं it's sufficient.
और भी एक समाप्त करना.
एक जजमेंट और है कि रेडीनेस एंड विलिंगनेस पर स्पेसिफिक इशू फ्रेम होना मैंडेटरी है.
But there is no contradictions. They have not participated in the proceedings. That is why, Lord, when there is a contradiction or they have defended my case, then Lord, those issues are required. When there is nothing, Lord.
The learned counsel for the
Lord, I have also
parties.
given Lord one thing, Lord, list of dates, and I have given Lord, in which Lord I have Lord mentioned all those dates.
Yes.
हाँ, इसमें हम सिर्फ ये दिखा रहे हैं कि 2000 जब से ये हुआ है, जब ये प्रोसीडिंग के लिए हम सूट फाइल किए हैं, उसके बाद जब नोटिस हुआ है, how they have entered their appearance, thereafter they have
avoided, they are not
and
good.
how many dates they have avoided, in what manner they have till again it was restored. Again, my Lord, he was given the chance to file WS. Again, my Lord, again, my Lord, he started avoiding those things. So whatever I have asserted, Lord, in my plaint and in the evidence.
ये 25 वाला जजमेंट आपने दिया.
Para, Lord, 82 to 88. And if the termination is there is no need to challenge the termination. Even that is also there in this case.
इसको ठीक से टैग करिए. आपको और कोई जजमेंट नहीं देना है. I hear it. अभी ज़्यादा टाइम नहीं है मेरे पास. We hear it. Yeah. Wednesday and Thursday are the days for first appeals, and Monday, Tuesday for labor matters. The hearing has commenced. The arguments have been inconclusive. Pose this case for further hearing. Day after tomorrow. आपको क्या बोलना है बताइए? आपका कौन सा केस है? नेक्स्ट नहीं, नेक्स्ट का फाइल है।
जजमेंट
हाँ, जजमेंट करिए पहले, नेक्स्ट का फाइल।
नेक्स्ट फाइल
लेट मी जस्ट से मेंशन करते हैं आपके अदर साइड कौन है? आप अदर साइड
आइटम 9 FA 62 of 2025.
you are otherwise ready.
Yeah, arguments.
What is the matter?
The arguments in this case has already been concluded.
Concluded.
Kindly see articulated 9/10/2025. Only for
ये कहाँ भटक रहा था ये केस?
with 3 and 4 was called for Miller.
थोड़ा सा ब्रश करना पड़ेगा, बहुत ही हो गया। क्या इसमें दिस इज फर्स्ट अपील और सेकंड अपील?
First,
What was the suit for? What was the suit for?
Suit was for declaration of title and for, basically declaration of title.
I have
My entire submissions have been.
No, I know it is there, but you know, just been washed out.
I'll start once again. I'll no difficulty. But
थोड़ा सा भी याद दिलाने से याद आ जाएगा।
बहुत छोटा सा है, straight forward है केस.
क्या मैटर है?
My predecessor in interest, the original landlord, they by registered deed, they transferred the property in the year 1921 in favor of one Prafulla Kumar Ghosh. And thereafter, the property was partitioned amongst his descendants, 4 sons. One son was allotted in the year 1950 in a partition suit. He was allotted the suit property. And that suit property, ultimately, he has his own grandson.
ये प्रफुल्ल घोष का कोई और भी केस डिसाइड किया क्या?
नहीं यही बात. Because this was heard in the
इसलिए तो नाम याद आ रहा।
हाँ. और this was reserved, but 2 things were there at the time.
You can do it on Thursday. Thursday?
Whatever is there.
Because Wednesday I have kept one first appeal. Maybe I'll dictate it to the court.
Whatever is convenient.
With the consent of the counsel for the parties, pose this case on Thursday. As first case, I think.
My submissions are
I will
mentioned
take
in
it.
order dated 8/10/2025 and 9/10. But I'll
आप
refresh the
आप
entire-
अपने साथ एक पॉइंट फॉर डिटर्मिनेशन लेके आएंगे,
ठीक.
दोनों जने जॉइंटली लेके आएंगे।
ठीक.
हाँ जी।
From the daily list at 10:30. Under reading for judgment, item 1, criminal appeal as a 548 of
इसका एक और जजमेंट क्रिमिनल अपील कॉल किए हैं।
Yes, ma'am.
Acquittal under section 307/34 IPC giving benefit of doubt. Conviction under section 341/34 is upheld, but the sentence is limited to the period already undergone. Conviction under 325/34 is modified to 323/34 and period already undergone with fine of rupees 1,000 to be deposited within 3 months. That is it.
Under reading for judgment, item 2, second appeal 72 of 2025.
This appeal is dismissed.
Where is it? Land acquisition का matter. So what is this?
There are certain land acquisition matters which we are going to post it. Wednesday.
Yes, Wednesday.
List में जितने भी land acquisition matters है सब Wednesday. ठीक है, 4-5 10 होंगे।
भेज देंगे छोड़
हाँ भेज
जी
ऑर्डर के लिए भेज दीजिएगा जितने भी आपके।
तो आज कैसे है आपको मैं भेज देता हूँ, ठीक है।